There we go. So in terms of the overview, I'm going to address two things. Generally, some rescinded and new rule making and proposed rulemaking, and then the legislative priorities. Really what we've seen so far is a reboot to the President Obama era rulemaking and legislative priorities. A lot of what happened in the first few hours to the first few days of the Biden administration was either staying or actually rescinding some of the rules that the Department of Labor had proposed, and some of which were either at various stages of enactment or soon to be enacted. With Congress being the way it is, I think we're going to continue to see a lot of the priorities addressed through rulemaking. We're going to see some attempts at legislative priorities. As you know, the House is able to pass things due to the minority or the majority in the House with the Democrats. The Senate, however, is a 50-50 split with Vice President Kamala Harris being the deciding vote for legislation that's passed through budget reconciliation or that only needs a majority. They're going to be able to get their legislation passed through. In all likelihood, things that require more of a 60 vote rule and that can be derailed by filibuster are going to have to be addressed to the extent they can be through more rulemaking or interpretations of the federal government. So obviously, one of the items that is big in President Obama's or President Biden's administration and his campaign was a push to a 15-hour federal minimum wage. You're seeing a little bit of that. So federal contractors, generally, their wages are going to be increased to $10.95 per hour. We're likely to see more federal minimum wage increases. There's already a proposal and an attempt to increasing certain federal minimum wage for contractors by $15 by 2022. The other thing, for those of you who sponsor temporary workers for immigration purposes, specifically H-1Bs, there were prevailing wage increases that were put into effect in 2020 by the Trump administration Department of Labor. Those prevailing wages were meant to, the impact was to supposedly level the playing field and to put US citizens and US permanent residents back to work over a temporary workforce coming in from other countries. One of the first things that was done was that those increased prevailing wages were again reduced back to their current levels. That doesn't mean that there's not going to be some increase in those, again, since a priority of the administration is to increase minimum wage and wages across the board. But at least for now, in terms of the H-1B processing, we're back to Trump administration Department of Labor rules on the prevailing wages, and those wage surveys have been adjusted accordingly. Again, keeping with the thought and the theme of increasing the minimum wage and increasing wages to those employees either perceived to be with the lowest wage rates or most impacted by the pandemic, you had the Department of Labor do a few things with the tip pooling rule. Again, the Trump administration had made some changes to the tip pooling rule. The Biden administration Department of Labor implemented a few of those, changed some of them, and has yet to issue guidance on others. So things that are in the works or recently have been implemented do with prohibitions on employers, including supervisors and managers, so that we keep the tips received by workers in the workers' hands, regardless, instead of their supervisors, managers, or owners. A record keeping requirement. So if an employer doesn't take a tip credit, to include non-tip workers such as cooks and dishwashers in non-traditional tip sharing arrangements, there are significant record keeping requirements for those employers over and above what has historically been required. Um, some of the more significant, obviously goes to the wages, is that the employer who collects tip for tip pools has to distribute those no later than the regular payday for the work week in which the tips were collected. And then there's a question over the 80-20 rule. Again, the 80-20 rule has to do with duties of individuals who share in the tip pool, not all of which are actually in the service to individuals collecting the tips. So more back of the house type of people. So those are some things to look at. The Department of Labor is increasing. The idea is to do away with the tip pooling. It appears to be an increasing the actual minimum wage to no less than 85% of what the minimum wage is for other workers. So that's in process. There are some increases to that wage due to kick in January 2022 and subsequent to that. One of the big rules that's going to affect a lot of employers is the Department of Labor's position and action on the independent contractor rule. As many of you know, the Department of Labor during the Trump administration issued an independent contractor rule, trying to add some clarity, trying to add some certainty to when an employee will, or when a worker will or will not be classified as an independent contractor or employee. And that rule did a lot toward narrowing the field down to basically 2 of the 8 or more tests that historically courts and the Department of Labor have looked at. The Department of Labor withdrew that rule. So essentially, they've gone back to some of the uncertainties of the economic realities test and the court decisions. Essentially, they're reviewing a totality of the circumstances. No one factor is controlling, although through a lot of court decisions, there's still a couple factors that predominantly are looked at, control of the employee's terms and conditions of employment, whether the employee derives all of their income from the work situation, and whether the employee holds themselves out to work for other businesses other than the main won't use the term employer, but the main company in which they're working, and considers them to be an independent contractor. So we're back to the pre-Trump administration, Department of Labor rules on independent contractor. There is likely to be a lot of activity. You also hear about this called misclassification of worker, because that is a priority of the President Biden's administration and his Department of Labor. A lot of the activity you're going to actually see them do through the National Labor Relations Board and through that rulemaking. And so I'm sure Chris and my other partners will be addressing that next week if you have an interest. It ties in nicely with some of their, the Department of Labor's and the NLRB's actions or proposed actions as to union activity and unionization of the workforce. So expect a lot of activity. Again, really look at your workforce. If you use a fair number of independent contractors, I highly urge you to go back and look at whether those workers are misclassified, or there's an argument as to whether they can be misclassified, because the ramifications are significant and far-reaching. So you have issues not only with the Department of Labor, you have IRS issues, because of course, if you consider somebody to be an independent contractor, you're not going to be withholding things like FICA, Social Security, Medicare taxes. You're not going to be paying your portion of unemployment on them. You're not paying workers' comp on them. So the financial issues are significant, also from a benefit standpoint. And that's the whole purpose of the Department of Labor and its withdrawing of the independent contractor rule. So another thing that's been happening is, as many of you know, that have either 100 employees or more, or are government contractors with a $50,000 contract, or 50 or more employees. The EEO-1 reporting was suspended during COVID. It has now reopened. And so those employers who had suspended the data reporting have until July 19th of 2021 in order to report both for 2019 and 2020, and that can be done online. EEOC initiatives. So we have the delegation of litigation authority that was done from the EEOC Commission during the Trump administration. You know, what does that mean? Over the years, essentially, the EEOC had delegated much of its litigation authority and decision-making of the commission to regional offices of the EEOC. The commission pulled back that litigation authority for a number of types of litigation, specifically those that influence, class actions, those that influence novel issues of law. Why did the EEOC Commission do that? Well, the EEOC Commission, until at least 2023, is controlled by individuals who are Republican appointees. While the vice chairperson of the commission is now a Democratic appointee, the commission, she does not get any more votes than the rest of the commission. And so the votes of the commission will tend to have a conservative Republican decision-making lean. Conciliation rules. There were conciliation rules that were put into place to make the conciliation process more transparent for employers. If any of you have been involved in EEOC conciliation efforts, at times you don't know the evidence against you, especially in class action cases. Sometimes they refuse to provide you names, number of people. If it's a hiring case, you don't even know or don't have the wherewithal to check if there were applications. So the EEOC put into place conciliation rules requiring certain disclosures. You're probably going to see some modification in that, going to some of the old rules, which I liken to, unfortunately, trial by ambush at times. And it really depends on who you're conciliating with. I mean, I think I found that there are individuals and offices that have different perspectives in how to approach conciliation, just like different lawyers have different perspectives. So that's something to look at and watch. The EEOC initiatives are definitely priorities related to disability and getting more disabled employees and workers into the workforce in life-sustaining types of jobs and wages. You're going to see a lot of priority on race issues, diversity and inclusion, gender equality, and LGBTQ+. As you know, the Supreme Court in 2020 actually ended the dispute over whether or not the Title VII protected individuals for sexual orientation, finding that the law did. So you're going to see the EEOC making movements and issuing priorities and engaging in litigation based upon those initiatives and priorities. OSHA initiatives. So again, OSHA will continue to put emphasis on worker protection. You're going to see a fair amount of litigation. You're going to see there be a more enforcement emphasis as opposed to a and penalty emphasis, as opposed to what you might have been seeing the last couple of years with regard to education and outreach. That is consistent with what we saw during the President Obama's administration and the OSHA and OSHA. Standard promulgation versus agency interpretation. You're going to continue to see a lot of agency interpretation. Just to touch upon one thing, and Oyvind and Sam will get into this a little bit more. In terms of standard promulgation, and there is a slide in here that just shows you, in order for OSHA, because of the process, to actually promulgate a rule or a standard, as the agency calls it, addressing something, ladders, general housekeeping, beryllium standards, all different things. It takes years. It can take 8 years, 10 years. There's some standards that are complex that took, 15 to 20 years to be promulgated by the agency. It is a tedious, difficult, lengthy process. So when the agency makes changes, a lot of those changes are done through agency interpretation of the standards already in place and or through something called the General Duty Clause. Now, the General Duty Clause, which is so far how OSHA has addressed the COVID issues, because they have not instituted any emergency standards, which is an exception to the standard promulgation rule. Essentially, it requires the employer, OSHA has to prove the employer recognized a hazard of serious death or bodily injury. Generally speaking, in order to do that, the OSHA has to point to some other agency's rules or standards. In the case of COVID, as Sam and Oyvind will talk to you a little bit more, that issue has to do with largely the CDC. So where I know a number of employers in the last few months have received complaints or letters about mask use, enforcement of mask use, and other things, with the CDC's new guidance on vaccination, OSHA has had to drill back on that a little bit. They may issue their own guidance. They have not yet. And they essentially have said that employers should follow what the CDC guidance is on that topic. So here you can see this goes through the OSHA rulemaking process. You can see stage 1, 12 to 36 months, down to stage 4. So it is a cumbersome, lengthy process. Stage 7, post-promulgation activities, enforcement. Pregnant Workers Fairness Act. In terms of some congressional actions that are out there, this bill passed the House. The bill declares it's basically unlawful to fail to make reasonable accommodations to pregnant workers. So it gives them a lot of the same protections that individuals who have disabilities have. It is in Senate committee right now. It probably, of all the bills that are pending, seems to have the most legs and traction and probability of passage in Congress. Next is the Equality Act. This did pass the House. Again, it is in Senate. It is before the Senate right now in committee. It prohibits discrimination on the basis of sex, sexual orientation, gender identity, includes public accommodations, facilities, education, housing, all of that. Essentially, what it's been meant to do is to make sure that the issue of equality based on sexual orientation and gender identity is settled legislatively once and for all. We have the Forced Arbitration and Justice Act, which passed the House quite a bit ago, 2019. It's sitting in Senate. Nothing's really happened with it. But essentially what it's meant to do, and again, getting on this theme of protection of workers and wages, is it's meant to prohibit pre-dispute arbitration agreements that force arbitration of future employment, antitrust, civil rights disputes. It would prohibit arbitration agreements, compelled arbitration for class actions, significant litigation or significant legislation, sorry, if this ultimately is capable of passing. It probably has the least opportunity of passing of the legislation that's out there. For no other reason, it's been pending for well over a year at this point. Elimination of restrictive covenants is another area that the Biden administration has issued directives in terms of its thought process, and again goes to protecting the flexibility of workers. It seems unlikely because it is legislation that would need to pass filibuster, and it seems unlikely that it would do that. However, the Biden administration could enact a rule through the Federal Trade Commission as something that is in restraint of trade, which of course is one of the arguments against restrictive covenants to begin with. So I'm going to turn the presentation over to Dan Finnerty at this point.
Excellent. There we go. Okay, there we go. Okay, thank you, Lori. Talked about a lot of issues on the federal level. Let's move to Wisconsin. Obviously, as Oyvind said, it's been a very long year. And I think in terms of constitutional push and pull in Wisconsin, I think we've seen more in the last 15 months than we've ever seen in terms of the back and forth between the legislature and the governor. So we're going to talk about that. The budget, what was in it, what was taken out, which items might get back in, and then getting Wisconsin back to work and how we're going to do that, in addition to some other items on the agency level, and moving from there. So, okay, so we had 2 executive orders that were issued by the executive branch. Both were overturned by the Supreme Court. The last 15 months for not only the governor and the legislature, but for all of us, and especially in HR, has been like, flying a plane without a flight plan or a manual. Pretty difficult, right? So in the first case, if we just look at some of the historical background, the Supreme Court found that Secretary Palm's Safer at Home order violated the promulgation of rules and how rules have to be promulgated. She didn't follow the necessary process. Now, obviously, there wasn't time to go through that process, so it didn't. The rules were not followed. The governor, if he had issued it, theoretically, might have stood up, but at the end of the day, that sort of left employers on their own until we go to the next slide. And Secretary Palm's second emergency order limited the size of, limited the capacity of indoor gatherings. And it effectively, in doing so, shut down a lot of Wisconsin small businesses that rely on people to come in, bars, restaurants, other sorts of organizations. I guess theoretically, we could say it also possibly helped Wisconsin turn the tide. That's maybe arguable, but at the end of the day, where we're at now is that Outagamie County has lifted its mask mandate as of May 13th. Milwaukee's was allowed to expire yesterday. And if you're in Madison or Dane County, your mask mandate expires today. So if we go to the next slide, where that leaves us is that we have a divided legislature and a governor on the other side. So it's difficult to get anything done. I mean, if you're somebody that votes split ticket, you vote Democratic for your governor and Republican for your legislature, this is what you're getting. But you see more push and pull in the budget. This is Governor Evers' wish list, increasing the minimum wage from $7.25 to $9.40 to $10.15 within roughly 3 years. The Madison Dream, repealing Act 10, right to work, and legalization of marijuana. I call it the trifecta. That was also in the budget, expanding FMLA substantially, most notably by reducing the number of hours required to qualify for Wisconsin FMLA from 1,000 hours to 650, which is roughly 4 months at a 40-hour week, and then expanding the Wisconsin Fair Employment Act protections to include gender identity and expression. We'll talk about that a little bit later because there's also a bill pending on that issue from just sex and sexual orientation. Sexual orientation obviously is not, as most of us know at this point, not the same thing as gender identity or gender expression. Also something that was briefly in place in 2008 or proposed in 2008, I should say, is that it would have allowed civil actions for Wisconsin Fair Employment Act alleged violations and compensatory and punitives in circuit court. So that would obviously add a lot more work to our circuit court judges. Mary, if we could move on. I'm sorry, Mary Beth. But then on May 6th of 2020, the Joint Finance Committee passed a motion that removed all of the foregoing items on the prior slide, which is to say that where it leaves us on the next slide is that the question becomes, is some of that going to be reinserted in the same way that it was reinserted in 2013? In 2013, if you recall, that was when a change that I was very excited about, and many of you I know on the webcast here were very excited about, that introduced the specific instances of misconduct and substantial fault. That was reinserted into the budget in the later stages after it had been taken out. And I kind of got wind of it beforehand a little bit, and I thought there's no way that's going to get in, and of course it did. So I rarely make predictions. But at the end of the day, it is very unlikely that any of these items will get back into the budget because there's really not a lot of appetite for pushing the governor's agenda through the legislature unless there is some quid pro quo. What are those quid pro quos? Potentially the bargaining items are the UI Trust Fund, which currently stands at $1.1 billion. If it is not back up to $1.2 billion, the taxes on employers go from Schedule D to Schedule C and increase. So the Republican idea at this point is to use some of the federal money to get the trust fund back up to avoid putting a tax increase on employers at a time when they're just coming out of the pandemic and they don't need it. So if you get reassessed this year and your tax goes up, it's going to be sort of a double whammy unless there's a legislative solution here. Let's move on to the next slide, actually, because the bargaining chip here, if we can move to the next one, is that there's Democratic support for a bill that does the same thing as I previously mentioned, prohibits discrimination based on an individual's gender identity or gender expression, identified in the bill as gender-related identity, gender-related appearance, gender-related expression, gender-related behavior, whatever that means, regardless of assigned sex at birth or gender on any official document. So that's a fairly broad brush in terms of a non-discrimination provision to be added to the Wisconsin Fair Employment Act. And that would also prohibit discrimination in public accommodation and other spots and go well beyond what we have currently with regard to sex and sexual orientation protection. That may be a bargain on that issue. If we could go to the prior slide, Mary Beth. There is also 6 bills currently pending. 6 bills, 3 in each house, 3 in the Senate, 3 in the Assembly, that prohibits businesses from discriminating against folks based upon their vaccination status. They all go at it a little bit differently. So it'll be it'll be hard to predict what's going to come out of this. But at the end of the day, if you assume this passes a Republican legislature, I find it difficult to believe that the governor would veto anything that prohibits discrimination. Just my thought. Again, I've been wrong many times, so take that for what it's worth. If we could go 2 ahead, Mary Beth, I'd appreciate it. So then the question that I've been struggling with a little bit here, and if you have any insight on this, please share it with me offline, There is an individual who shall be nameless outside of Wisconsin who has filed over 470 Equal Rights Division complaints. I hear stories that they used to come in filing boxes, and then an individual at ERD used to have to hand them out to the investigators who he would generally do it on Fridays because he found they would be in better moods on Fridays, and then they would not be angry at him by the next week. He's got no intent to get a job in Wisconsin, relocate to Wisconsin. He literally searches Indeed.com and other sites for the words clean criminal, and that usually pulls up your application sites that have clean criminal record in them. And if you ask for that, that's a violation of the arrest and conviction record provision in the statute. You know, there's not a whole lot there in terms of damages, but at the end of the day, we're hoping to address this issue and keep this individual from levying taxes on Wisconsin employers. Let's just say that. So let's go on to the next one. So if you have any stories on that, please share them with me. I'm going to try and see if we can work with Trade Group to get that done. So how are we going to get Wisconsin back to work? The work search waiver has been in place since last spring. You know, it's tough to go out and find a job when there's not a whole lot of jobs to be found. It was set to expire on July 10th of 2021. The legislature acted a few weeks ago to rescind that waiver, which means that work searches were required, and they were required to begin 4 days later on Sunday, May 23rd. So UI recipients, if there are any on your UI account, they are actively required to be searching for work, which requires four actions that constitute a job search per week in order to obtain benefits. And they have to certify that information to the Division of Unemployment or the Unemployment Insurance Division that they are actively engaged in a work search in order to obtain those benefits. So if we could move on, what we're trying to do here, what the legislature was trying to do is incentivize employees to get back to work. In part, they want to reallocate that $300 a week that employees were getting to the UI Trust Fund to avoid a tax increase on employers. A work search may not be required in certain circumstances that I've outlined here. And we had a question come up a few weeks ago. You know, employees working reduced hours that went from 40 to 32 or, you know, thereabouts. Those folks are not actively required to search for work because of that reduction in other circumstances. But, you know, at the end of the day, if you're going to make any offer of work, whether it's to a current employee, a former employee, or a new employee, you got to make sure all those work offers are clear. What the job is, what it entails, what it pays, what the hours are, when it starts, and how to communicate your acceptance. Those obviously should always come from somebody who has the authority to make that offer. But if you do that in circumstances where you have, you know, folks on your unemployment insurance account and you offer them work, that can help you to communicate with the UI division and report situations in which employees refuse those offered hours. If we could move on, Mary Beth, I'd appreciate it. You can report those situations to unemployment, and in other situations where you have employees who are applying and then they're just ghosting their interview, they're not showing up, you know, they're wasting your time. You can report those as well to unemployment. So, I mean, if you're doing massive hiring and you're interviewing 20 people a week and 5 of them just don't show, you can report that to unemployment and they will take appropriate action to investigate that. And if someone's on unemployment, they will act, the division will act accordingly. There's a good FAQ on the UI division's website, so check that out if you can. Moving on to equal rights. There was a case decided in the Wisconsin Court of Appeals earlier this year involving a provision that some folks are familiar with on the call, an arrest and conviction record discrimination case where an individual applied for employment with a facility that was rather large, 10,000 square feet, lots of cameras, but also lots of hidden areas. And the individual would have also been required to go to trade shows and the like. Conditional offer was made, background check was conducted, which revealed convictions for strangulation, suffocation, fourth-degree sexual assault, battery, and criminal damage to property. Those situations were generally limited to domestic disputes. And ironically, that's the issue that sort of turned the tide. The company rescinded the offer for a number of reasons, which I've noted. But at the end of the day, the commission found that the individual would have that the job was not substantially related to his employment. So, because it was limited to domestic circumstances, the commission found that there was no substantial relationship. The circuit court reversed. The Court of Appeals took up the case and found that the commission should be affirmed. At the end of the day, on any of these reviews in circuit court or the Court of Appeals, the Court of Appeals reviews LERC's decision. So it is the decision of the commission which matters. And at the end of the day, what they found is that their decision was based on the assumption, and we'll talk a little bit about it, the assumption that someone who commits domestic violence or violence under domestic circumstances will not commit or is not likely to recommit in situations outside of a domestic circumstance. I struggle with that a little bit. Mary Beth, if we could go to the next one. So what the Court of Appeals found is, if the question before us was whether Palmer is likely to again be violent toward another woman with whom he is in a live-in boyfriend-girlfriend relationship, the answer would certainly be yes, that the criminal history would be substantially related to the job. But that wasn't the question. So they found that the employer had not established the substantial relationship test. It's on review in the Supreme Court. Again, the LERC decision is the one at issue. The question here is whether you can read the statute to say that it has to be limited in nature to the specific circumstances in which the individual is placed in the job. I think it's a very narrow interpretation, but I think what it'll come down to is what the language of the statute says and how it should be reasonably construed. Again, we've got a fairly conservative Supreme Court, so that may play into it. And this may possibly get reversed in Cree's favor, such that the petition or the claim would be dismissed. There's also unreasonable refusal to rehire case coming out from the Court of Appeals today. Waiting on that one, and it was not out as of 15 minutes ago, so we'll be looking for that one and perhaps write about that. If you're interested in unreasonable refusal to rehire, please give us a shout and we can talk about it. Let's move down to the agency level. So here's what happened at the Equal Rights Division last year. In general, their case processing decreased by about 50%. What they did is that they canceled hearings and turned them into settlement conferences and gave parties the ability to go to a WebEx hearing. If you said yes, your matter proceeded along path one. If you said no, which I did in a couple cases, the matter proceeded along path two. And then at some point in July or August, the division decided to combine those paths. And what they like to do is they like to take the cases as they're numbered in order. So that just created a real mess in terms of how to keep those cases in order. And I think what they did is they ended up taking them out of order and just slotting the cases where the party had said no back into the pile, essentially where it was. The net result of that is that I've got a case where we had a no probable cause decision in October of 2019, September, October 2019. It was originally set for a hearing last spring. At the end of the day, we're not going to get a hearing date until September of 2021, and that hearing probably won't take place until next spring. So it is causing sufficient or significant backlogs in the equal rights system. If we move on to unemployment, that backlog that you heard so much about in the news in claims processing has turned into a backlog in hearing processing. So, obviously there's the cases out there where somebody misconstrued the pandemic, benefit provisions and denied someone unemployment that you hear about in the news. But at the same time, we still have these other cases where an employee committed misconduct, an employee quit, in sort of your more garden variety cases. I've got a number of cases that have been pending hearing for 2-3 months, and we haven't heard anything. I think unemployment is not only struggling with the numbers, but they're struggling with whether they want to go 100% toward online hearings, which seem to be working decent, but it is causing, again, significant delays. We might not get a hearing date for 2 to 3 months, and I know there's some folks on the call that we have a matter with. So keep that in mind. At some point, I'm going to come to you and say, what are your unavailable dates? And that probably won't be until sometime this summer. So if we pop over to the federal, as Lori mentioned, Bostock versus Clayton County was a very significant case that essentially construed Title VII to prohibit discrimination against employees based on sexual orientation and transgender status. And the way the court did that, the majority of the court did that, I should say, is a very straightforward textual analysis. They didn't look at the language in historical terms or the original meaning of the language. They simply used the plain language of the statute to say that sex applies to an employee being homosexual or transgender. At the end of the day, that's a big decision. So if you don't have your harassment policies and your non-discrimination policies updated, we would certainly recommend that. Additionally, in Wisconsin, in the Eastern District and the Western District, all parts of the state, in addition to seeing some complaints filed in state court, Fair Labor Standards Act cases are up and they're being filed virtually daily. Great time for a wage and hour audit. If you do have any potential liability, get rid of it, clear it off the table. That starts your 2-year or 3-year statute of limitations running, and then you can move on from there. Those wage and hour audits are always a good idea. I mean, if you're paying a salary without paying any overtime to an employee who is not professional, administrative, or meet one of the other criteria, you may be in violation, something to definitely look at and talk about. We're seeing a lot of those cases being filed, in addition to ERISA claims being filed against plan administrators. On those points, in terms of Fair Labor Standards cases, Title VII, equal rights cases, important to check your insurance coverage to see if someone else at your company has gone out and got an employment practice liability insurance policy. If that is the case, you want to check out and see if there's a choice of counsel provision in there. We appreciate being endorsed on those policies. That gives you the option to use us as a firm. If you don't feel like we're the right fit for a case, certainly you're not obligated to do that. But at the end of the day, it provides you with more options in terms of using us as counsel, as opposed to having an insurance carrier, many of which we have good relationships with. And it's certainly possible we could represent you, but we don't represent all the insurance carriers or do work with all the insurance carriers. So this allows you to make that choice instead of having your insurance carrier partners make that choice. So with that, we'll finish up there and see if anybody has any questions.
Okay, Dan and Lori, at this time, there are no questions.
Thank you so much. So what we will do now is turn it over to Oyvind and Sam to talk about COVID-19 and return to work.
So for the remainder of the time today, Oyvind and I are going to discuss COVID-19 and return to work issues. Just as a brief overview, we'll be discussing vaccinations, encouraging or mandating those in the workplace, ADA and religious accommodations, which go along with the vaccinations, as well as other workplace accommodations, COVID-related leave, and then other return to work considerations, including medical requests, masking, and social distancing. So unless you've been living under a rock, I think we are all aware that there are currently 3 vaccines that are available through the emergency use authorization granted by the FDA. And that emergency use authorization is a mechanism for the FDA to formally authorize unapproved products for temporary use due to the public health emergency. So we'll see, I'll talk a little bit later about current litigation in regards to that emergency use authorization. Wisconsin is currently ranked 13th nationally with 43.5% of the population vaccinated. Of course, that was as of last week, and those numbers continue to change on a daily, even hourly basis, and depends on several things, including who is authorized to receive the vaccine, as well as how many dosages each state receives. So fully vaccinated, as we'll use the term today, as well as with the CDC and OSHA and other agencies, means 2 weeks after the second dose of the 2-dose series of the Pfizer or Moderna vaccine, and then 2 weeks after the single dose vaccine of the Johnson & Johnson. So now that the vaccine is becoming more accessible to the US public, more and more employers are asking whether they should mandate vaccines. Specifically, last month we saw the CDC say that fully vaccinated individuals can now resume their pre-COVID activities. So with that, many employers are questioning whether they should mandate vaccines really to get their workplaces just back to the norm. The EEOC currently does allow for mandatory vaccination policies, provided that you accommodate medical accommodations and then sincerely held religious beliefs. Of course, just because this EEOC says you can, there's other considerations that employers need to make prior to implementing those policies. The EEOC has made very clear in its most recent guidance put out last Friday that they're only issuing an opinion based on the federal discrimination laws. So the legal issues beyond that with the Fair Labor Standards Act or workers' compensation issues or issues under that emergency use authorization statute, those are beyond the EEOC's jurisdiction. So let's talk about one of the first issues you'll need to address or likely need to address if you have a vaccination mandate. You're going to have to consider how to or if to accommodate individuals for medical reasons. The ADA allows an employer to have a qualification standard, such as the vaccination requirement, so that individuals do not pose a direct threat to the health or safety of other individuals in the workplace. However, that standard, if it excludes individuals with a disability, there could be an ADA violation. So in those circumstances, the employer is going to have to make an individualized assessment as to whether that unvaccinated individual poses a direct threat to the workplace. In analyzing the direct threat, the EEOC says we need to look at the duration of the risk, the nature and severity of the risk, the likelihood of the potential harm, and then the imminence of the potential harm. So what does that mean exactly? Well, the EEOC has laid it out for us that they would like us to consider the current medical knowledge about COVID. So what is the level of community spread at the time of your assessment? And what is the CDC, what is their current medical knowledge about COVID? You'll also need to consider the particular unvaccinated individual. What are his or her medical conditions, circumstances, and risks? So that's going to require you to get medical information from the individual. And then, of course, you're going to need to assess your particular workplace, not only the workplace as a whole, but how that unvaccinated individual fits into the workplace. So does he or she work alone or in a group setting? Is he working inside or outside? What is the ventilation that you have available? Does he or she have direct contact with others or customers? Are others in the workplace vaccinated? Are you still requiring masking or social distancing? All of those things will go into your analysis as to whether someone poses a direct threat. Now, if after you do this assessment, you determine that there is a direct threat, the employer still can't automatically exclude someone and certainly can't terminate someone just on that basis. At that point, you need to undergo the interactive process and determine if a reasonable accommodation would eliminate or reduce the risk. In the EEOC's recent guidance, they've given us a series of accommodations that may reduce or eliminate the risk, including continued masking, staggering shifts, improving the ventilation, social distancing, or getting periodic tests for COVID. All things that we've really already been doing prior to the vaccine. Another consideration that you'll have to make is if there's religious accommodations. If an employee objects to the vaccine on the basis of a sincerely held religious belief, the employer is going to need to provide a reasonable accommodation unless it would pose as an undue hardship for the employer. Generally, when you're faced with a religious accommodation, you should ordinarily assume that the request for a religious accommodation is based on a sincerely held belief. This is because Title VII very broadly defines religion. It includes all those traditional religions that we're aware of, but also new and uncommon religions and practices that only small groups of people practice. You'll also have to consider whether there is an undue hardship. The undue hardship bar is lower in regards to religious accommodations as opposed to the ADA accommodations, but the employer would need to have objective evidence to show that there is at least a de minimis cost or burden on the employer. Beyond just these religious and ADA accommodations, the EEOC has cautioned us that as with any employment policy, employers need to be sure that the policy doesn't disproportionately exclude employees based on a protected characteristic like race or national origin. Because some demographic groups face barriers in receiving the vaccine and having access to healthcare, they may be more likely to be negatively impacted by a vaccination mandate. Employers will also need to offer job accommodations or exclusions for pregnant employees. If an employee seeks an exemption or an accommodation, the employer needs to be sure that that employee is treated the same compared to those in their ability or inability to work. So because of these accommodation issues, before a mask requirement is implemented or a policy is implemented, before a vaccination requirement is implemented in the workplace, managers and supervisors need to know how to recognize when an accommodation request is made, and then what to do with that accommodation request. Who to pass it on to. So in addition to these accommodation requests, there are some other considerations that you should make prior to implementing a mandatory vaccination policy. First, workers' compensation issues. If an employer mandates the COVID-19 vaccine and an employee develops a reaction that requires medical attention and time off work, that's likely going to be compensable under state workers' compensation laws. Also, we need to consider OSHA's standpoint. Typically, OSHA requires employers to maintain and prepare records of recordable illnesses or injuries in the workplace. Prior to last week, OSHA had said that adverse reactions as a result of a mandated vaccine would need to be recordable or were recordable. OSHA has now, as of last week, revised that position and says that because it doesn't want to discourage vaccinations, it's not going to enforce the recording requirements at this time. but it is going to reassess that recording requirement in May of 2022. Another consideration that employers need to make prior to implementing a mandatory vaccination policy is the Fair Labor Standards Act. We haven't gotten formal guidance on this from the Department of Labor, but if an employer requires employees to receive the vaccine, then the time spent doing so is likely going to be compensable because it's an indispensable part of the workday or work activity. There's also been various legal challenges that have popped up beyond just the EEOC and their jurisdiction. Specifically, last week, we saw a case pop up in Texas, a class action lawsuit where individuals were challenging an employer's mandatory vaccination policy. There was a very unique state law that prohibited experimentation on human subjects without their consent. So those class action plaintiffs are arguing that the state law has been violated. A more common argument that we could see in any state really is one that was raised in New Mexico back at the end of February. In that case, the employee also challenged a mandatory vaccination policy, stating that it violated the provisions of the emergency use authorization statute. That statute states that employees need to be informed of the option to accept or refuse the administration of an unapproved product. The employee argued here that he didn't get that option to accept or reject because if he rejected it, he would have been terminated or disciplined. We're not sure what we'll see from that case. Under the emergency use authorization, it does state that employees must be, or individuals must be informed of the option to accept or refuse the product. But it also states that employees or individuals need to be informed of the consequences if they do reject the unapproved product. So it does implicitly allow for consequences of refusal. But although that case may not go anywhere, it's important to know that these litigation risks are out there. Finally, another consideration that you need to analyze is the state or local laws. Bills have been introduced or are pending in many different states that would prohibit employers from mandating vaccines. Just last month, Montana passed a law that not only prohibits employers from mandating or disclosing their immunization status, but also makes the vaccination status a protected category. So we don't currently have any laws in Wisconsin, but if you are a multi-state employer, it's important that you consider these laws at the local level. So with all of these complexities with mandatory vaccinations, the most common approach that we're seeing is to offer vaccination incentives. Historically, the EEOC has limited wellness incentive programs, and for that reason, employers thought they would do the same here. Just last week on Friday, the EEOC finally gave us clear guidance on this issue as a treat going into Memorial Day weekend. They've given us the green light stating that employers can offer incentives to employees for providing documentation or confirmation of the vaccine from a third party. However, if the vaccine is administered by the employer or the employer's agent, in those cases, we can't make the incentive so persuasive as to be coercive. So in those cases, we would only be permitted to offer those de minimis benefits. Of course, there are still considerations to make, even if we have the vaccination incentives. There isn't clear guidance, but ADA and religious accommodations still can be required. The EEOC has indicated that employers can't disproportionately exclude individuals because of a protected category from their policies. So we need to determine prior to implementing these policies how we will address those issues. Another issue to consider is the Fair Labor Standards Act. If the employer recommends but does not require the vaccine, then time spent getting it likely is not going to be compensable, but you need to also consider your state laws. Another consideration is that if the employer offers some kind of a bonus, you need to keep in mind that those non-discretionary bonuses ordinarily would be included in the employee's regular rate of pay when you're calculating overtime. There are some exceptions to this under the Fair Labor Standards Act and ways to ensure that it doesn't impact the overtime rate. But those are things that you need to consider and determine prior to implementing the policies. And of course, if you're going to have a vaccination policy, a mandate or an incentive, employers want proof of the vaccination status. The EEOC has said that employers can ask employees for proof of the vaccination. However, those vaccination records are medical records that need to be kept confidential in the employee's medical file. Employers also need to ensure that they're limiting their questions to the vaccination status only and not seeking additional medical information. And then, of course, if you're going to ask for vaccination cards or proof of vaccination, you're going to want to do that for everyone, not only a select group of people.
All right. Thank you, Samantha, for that update. And I apologize for the technical difficulties we've had today. I figure after a year and 3 months of doing this, we'd be a little better at it. But I'm going to talk a little bit about kind of what the workforce is looking like. The American workforce, as many of you have likely heard, is likely to change significantly with work at home and telework as being much more prevalent. Saw some interesting statistics that pre-COVID, only about 16% of the United States workforce worked remotely. That number went up to approximately 65% during the pandemic. Another recent survey, 58% of Fortune 500 executives surveyed indicated that they anticipated reducing the amount of office space that they will need in the future because of COVID. So obviously what your workforce will look like is going to be very dependent on the nature of the business. Certain workplaces, manufacturing, the service and hospitality fields and others needs to be done in person, and there really is no opportunity for work at home or telework. In other areas, however, telework is kind of becoming the new reality. I was actually at an in-person conference down in the Keys last week or 2 weeks ago, which was great, by the way, actually interacting with people face to face. But one of the surveys that was done in the room, and it was very unscientific, but there was well over 100 people in the room, and it's attorneys and insurance professionals. And the question was asked, how many of you anticipate having all of your workers back 5 days a week once kind of the pandemic is officially declared over by the World Health Organization? And not a single hand went up in the air, which I thought was very telling. Now, again, that's an industry and a field where the majority of us have been working remotely. But so for better or worse, I think work at home and telework is going to become much more prevalent moving forward. So in that context, one of the things we're seeing with employers now pushing employees back into the workplace are employees who are resisting returning to the workplace. And the reason for those are typically, there's three different typical reasons. One is an employee who has a serious health condition, underlying health condition that makes them more susceptible to becoming very sick or catching the COVID virus. We'll talk a little bit about more than that kind of category of people in a minute. The second category is individuals who typically have some type of a medical condition that makes them either unwilling or unable to come back to work based on anxiety or stress or something, where they are concerned to the point of being incapacitated that if they do come back to work or are forced into the workplace, that they're going to get COVID or get sick. The third category is those individuals who simply prefer to work at home. They've been working at home for the last year plus, and they like to continue doing that. For the first two categories of people, there may be a need to accommodate and look at whether or not the medical condition rises to the level of a disability, and if so, whether there's a reasonable accommodation for that individual. The third category, those that simply have a preference, you as the employer have the right to designate whether a job is in person or whether it can be done remotely. And if you want an employee back into the workforce or workplace for whatever reason that might be, as long as there isn't a medical or religious reason why the employee, which you don't really see very often, but a medical reason why the employee wouldn't be able to come back to work, you can force that employee back. Now, if an individual does have a medical condition that prevents them from returning to the workforce, you'll need to engage in, Sam talked about that interactive process under the ADA in determining and finding whether or not there's a reasonable accommodation that would allow the person to continue to do their job. And in some circumstances, maybe being in the office or being physically present at the workplace is going to be absolutely essential. But you need to engage in that interactive process and determine whether or not there are alternatives that may suit the individual. In doing that, you do have the right to request medical documentation of the individual's disability, and that information can focus on what the disability is, how the disability creates a limitation, how the requested accommodation would address those limitations, whether another accommodation potentially could be appropriate, and how the accommodation would enable the employee to perform the essential functions of the job. So the standard is whether or not the medical inquiry is job related and business and consistent with business necessity. So as long as the information you're seeking is related to the ability of the individual to do their job, it's going to meet that standard. And certainly in the context of mental health type issues, anxiety, depression, where the need for the accommodation is not medically apparent, you absolutely do have the right to request medical documentation to substantiate that accommodation request. As you're going through the process, again, the flip side of a reasonable accommodation is whether or not the accommodation would pose an undue hardship on the employer. And that's going to be a thing I think we're going to be litigating over the next year plus, is an individual who has been able to work remotely at home. You're saying now, well, it might be a hardship to continue to allow you to do that because everybody's back in the office, and we need that collaboration and the work, people working together in one location. And the employee's comeback is going to be, well, I did it for a year effectively, and what's changed now? One point that the EEOC has made is that an individual who, this I guess would be the fourth category of individuals, somebody who says, I'm not comfortable coming back to work because if I catch COVID, I have somebody at home who is very susceptible or could get very sick if I bring the virus back home again. And the EEOC and the law has made it clear that you are not required to provide an accommodation to an employee in order to avoid exposing that employee's family member. So with respect to telework, especially in the context of individuals who have a medical condition that puts them at a higher risk of severe illness, you're probably less likely to be required to allow that employee to telework. The CDC has identified a number of conditions that meets that higher risk of severe illness, things like cancer, chronic kidney disease, chronic lung disease, dementia, diabetes, Down syndrome, heart conditions, HIV, immune-compromised individuals, liver disease, pregnancy, individuals who have had organ transplants. There's a long list. Those are kind of hitting some of the bigger ones. But individuals who have that higher risk of severe illness, you also then have to consider the OSHA general duty clause that Lori talked about, that you have an obligation to make sure that you keep your employees safe from general workplace hazards. And if there is an individual who has this higher risk of severe illness, you do have to consider the OSHA general duty clause to make sure that you can keep employees who are coming back into your workforce safe. So I think in this context, what we're seeing is employers that are considering, if telework truly works and the person can be effective, maybe allowing telework is the right accommodation. In other situations, it may be staggered shifts. It may be moving the person to another location within the workplace where they're less exposed to others, maybe requiring continued masking or continued PPEs to make sure that that person doesn't catch the virus in the workplace. The fact that an employer excused performance of an essential function during the period of time that the pandemic, during the last 16 plus months, if you sent employees home or you said, well, during this pandemic, you're not going to be required to perform certain aspects of your job, simply because they were excused from that essential function during the pandemic, doesn't mean you need to excuse that on a permanent basis. Once the pandemic is declared kind of over, or there's been declared herd immunity, the essential functions of the job are still the essential functions of that job. And you, as the employer, under the ADA, can require employees to perform all of the essential functions of the job with or without an accommodation. Sometimes we see the flip side of this, which is individuals who want to come back to work, but you as the employer are concerned that if we allow this employee back into the workplace, he or she could potentially expose or potentially make the rest of the workplace sick. It may be somebody who isn't vaccinated, or somebody who is engaged in high-risk activities, or somebody who you just feel may potentially make the rest of your employees sick. Simply because somebody has a medical condition that makes them more susceptible under the CDC guidelines is not a sufficient basis to exclude that person from the workplace. You can't say because you have diabetes, you can't come back to work because we're concerned you're going to get sick. If you're going to exclude somebody from the workplace, again, you need to engage in the interactive process and make sure that there are no other reasonable alternatives to allow the person back into the workplace safely. And if you are going to go down that road, you need to establish that bringing the employee back to work creates a direct threat to that employee's health or safety, or the health or safety of a coworker. High standard to meet, and it needs to be based upon objective medical evidence. So if there is going to be, if you do want to go down that road, you need to have an individualized assessment based upon reasonable medical judgment, and typically a fitness for duty type examination to see whether or not the person can safely return to work. Medical exams and inquiries in general, as I mentioned, they need to be job related and consistent with business necessity. A number of things that have been found to be reasonable: asking somebody why they have been absent for a period of time, asking about travel, asking whether they are experiencing symptoms associated with COVID, like fevers and chills, cough, shortness of breath, sore throat. You're allowed to ask that. You're allowed to ask whether or not somebody has been in close contact with somebody who has tested positive. You're allowed to screen your employees. You're allowed to do temperature checks. Those have been deemed by the EEOC not to be medical examinations under the ADA. So there's a number of things you can do. A few things you cannot do. One is you cannot administer antibody tests to determine whether or not somebody actually have antibodies. That is considered a medical examination under the ADA. So you want to avoid that. You also need to avoid asking questions, medical questions about an employee's family member and whether they are sick and those types of things. So you can ask about close contact, but if you're starting to ask questions about individuals' specific family members, that could potentially implicate the Genetic Information and Non-Discrimination Act. Any information that you do capture needs to be kept confidential and separate from the employee's personnel file. If you are doing, for instance, temperature checks, you may want to consider whether to actually keep copies or keep records of that information. Again, if you're keeping the records, then you need to keep it confidential and you need to segregate it and do all those things. If the concern is simply we're going to check temperature when they come into the workplace, and if they pass, there may not be a need to keep that information. Similarly with what Sam was talking about, vaccination cards, if you are requesting proof of vaccination, you may simply want to look at the card, check a box, and not actually make a copy or keep it, because if you keep a copy of the vaccination card, again, it needs to be kept confidential and separate from the rest of the employee's file. For that, I'm going to turn it back over to Sam for a quick update on EPSL and EFMLA.
So just as a refresher, last year Congress enacted the Families First Coronavirus Response Act. And essentially that required employers with less than 500 employees and some public employers to provide 2 buckets of leave. One was the emergency paid sick leave, which was 80 hours of COVID-related sick leave, and then emergency up to 10 weeks of emergency FMLA leave. So to protect employees who needed to take leave due to childcare or schooling issues. That was required until December, the end of December of 2020, and then was extended on a voluntary basis through March. I should also mention that those covered employees who did offer the leave received a dollar-for-dollar tax credit on the amounts paid to employees who were taking the leaves. When that was extended through March, those tax credits also, or the ability to seek the tax credits also was extended. In March, President Biden signed the American Rescue Plan Act of 2021. And this then again extended the sick leave provisions and the refundable tax credits through the end of September. And not only did it extend the tax credits and the leave itself, but it also expanded on what the leave could be taken for. The notable expansions were, one, that employees could receive a new bucket of paid sick leave. So it's traditionally been capped at the 80 hours, and as of April 1st, they could take a new bucket of 80 hours of paid sick leave. Of course, there was no carryover from the hours that were provided prior to April. So this was regardless of what they took or what they didn't take prior to April 1st. The expansion also included that the EFMLA, while it was 10 weeks of partial pay, now it is 12 because the first 10 days now can be paid under those provisions. And then the qualifying reasons for the leave under both the sick leave and the EFMLA were expanded significantly. Here are some bullets of how it was expanded. An employee could take it for COVID quarantine or isolation if he had symptoms and were seeking a diagnosis. And then most notably, an employee could take the leave for obtaining a COVID-19 vaccine and recovering from the adverse reactions to that vaccine. And then for the EFMLA, you can now take those for all of the same reasons that you can the sick leave. So greatly expanded the qualifying leave reasons under there. I also wanted to mention that even if you don't provide the EPSL or the EFMLA, an employee who works for a covered employee who suffers from COVID-19 symptoms could qualify for your traditional FMLA leave. So if an employee is seeking FMLA, you need to be sure that you're obtaining the medical certification to determine whether it qualifies as a serious health condition under the FMLA provisions.
All right, thank you, Sam. The last thing we want to talk a little bit about today is kind of the masking issue, which now, as everybody's coming back into the workplace, is becoming or has been an issue and kind of continues to be an issue. As Dan alluded to, there's no statewide mandate to wear a mask anymore. Employers still have the right to determine whether or not masking will be required in the workplace, but there's no state law that requires it, nor, as far as I'm currently aware, any local city or county municipality requirements with respect to masking. Milwaukee's expired yesterday. Dane County, Madison expires as of today. And I think all the other local mask mandates, at least that I've seen and heard about, have expired or are about to expire today. So as an employer, what do you do? What is the best practice with respect to masking? The CDC says that fully vaccinated individuals can resume activities that were done prior to the pandemic. resume activities without wearing a mask or staying 6 feet apart, except where required by state and local law. Again, there aren't any, at least here in Wisconsin, that I'm aware of. So the only thing you're going to be limited to is local businesses and workplace guidance. So again, an employer does have the ability to require masks in the workplace, even if the CDC says that employees can generally, or individuals can generally, go back to normal activities without wearing a mask. And there's also no need, according to the CDC, to be tested or quarantined after being or exposed to someone with COVID-19 unless the employee or the individual becomes symptomatic. Certainly if they are symptomatic, they should get tested. Some exceptions to that are deal with healthcare workers, employees in correctional or detention settings, and employees who work in homeless shelters. Those individuals, if they are exposed to somebody with COVID-19, should still get tested, even if they're not symptomatic. Lori talked a bit about OSHA. At this point, OSHA has not promulgated any rules or guidance as to masking. There is this general duty clause under Occupational Safety and Health Act that requires you to keep your employees safe. But at this point, they have not issued any guidance. It's unclear whether any guidance will be forthcoming. It seems that with the numbers of infected individuals going down significantly over the last couple of weeks and month, that it's possible there may not be any guidance from OSHA. So what OSHA is saying is you need to follow the CDC guidance. And so under the CDC guidance, you need to continue to keep employees safe. And what does that mean? Well, it may mean if you observe an employee experiencing symptoms of COVID, you may need to send that employee home. You may still require unvaccinated individuals to wear a mask in the workplace. You may require, and you should require, and continue to keep the safety protocols you've had in place for the last 18 or 16 months in place, with sanitation stations and wiping down, things like that. I think will go a long way to meeting the general duty clause under OSHA to say that we're keeping our employees as safe as reasonably possible. So that goes then back to the vaccination question of what do you do with individuals? Do you require proof of vaccination? If you're going to allow employees not to wear a mask, are you going to require proof of vaccination? And again, that's entirely up to the employer, whether you want to require verification or proof of vaccination. It's not required. You can, if you do require it, you can either require the employee to show their vaccination card. You could have them sign a statement verifying that they have been vaccinated. But if you do keep that information and you now know that certain individuals are not vaccinated, again, you may have that additional duty to make sure that that employee continues to wear a mask in the workplace. What I'm seeing for most employers is you're taking employees at their word. And the rule is if you're fully vaccinated, you can come back to work without a mask. If you are not vaccinated or fully vaccinated yet, or if you're more comfortable wearing a mask, you should continue to wear a mask. I actually had a situation which I think was a horrible example of what employers shouldn't do. Is they have approximately 20 employees, and 19 of the 20 employees were fully vaccinated, and one individual, I'm not sure whether it was a medical or personal situation as to why she didn't want to be vaccinated, but one individual who wasn't vaccinated. And because of that, the employer required all 20 employees to wear a mask at all times in the workplace. Well, the 19 individuals, as you can imagine, were not too pleased with the one individual who decided not to be vaccinated. So again, the most common approach I'm seeing with employers is take employees at their word and continue to follow the CDC guidelines with respect to masking. Couple kind of final considerations here. Make sure you comply with the general duty clause. We talked a little bit about considering employees providing proof. Designated a supervisor manager to handle concerns. I think this is a smart practice. Kind of have one point person for any issues related to COVID and vaccination and masking. that can, one, address the concerns consistently and uniformly, but people also know kind of who to go to rather than approaching individuals directly, because not a good practice to have other coworkers or managers asking questions about employees, whether they've been vaccinated, why they haven't been vaccinated. Again, so once you start asking questions about why they haven't been vaccinated, that may trigger information that may trigger an ADA accommodation, and there may be a medical inquiry and raises all sorts of issues. So it's okay to ask whether somebody's been vaccinated, but I would not recommend taking the next step and asking why they haven't been vaccinated if the answer to the question is no. So that is essentially what we wanted to cover. This is a constantly evolving area of the law. We've seen, as Sam mentioned, with some of these standards and guidelines, they're changing almost daily, certainly weekly. So keeping up on the changes and what the requirements and what the reasonable employer is going to do is changing as we learn more and more about COVID and how it's transmitted. So I want to thank everybody for their time today. I'm not sure if there was any questions, Mary Beth?
Yeah, nope, at this time, there's no questions, Oyvind.
Okay. Well, I guess we answered all your questions in our speech, or nobody's listening, we don't know. But thank you for coming, and thank you for spending your morning with us today. If there are any follow-up questions or things that you think about later, feel free to reach out to me or to the other participants or presenters here this morning, and we'd be happy to help you through any issues you might have. So if there are no questions, as I promised at the beginning of the presentation, we're going to draw a winner for an Amazon gift card, and Mary Beth did that randomly and just sent me the name of the winner. So hopefully she is still on. The winner of the Amazon gift card is Jessica Sullivan from Naturescape. So congratulations, Jessica. We'll be sending your gift card in the mail, and it should be arriving shortly. So hope everybody has a great day and stay safe, and hope to see you soon.